have probably already noticed is that when you log into this meeting, your web cameras are not on. You are therefore not visible on the screen and your microphones are on mute. If you do have any questions you would like to ask, please click on the hand icon and wait for us to turn on your microphone. There's also a chat function in Zoom where you can submit written comments, and this function is set so that your comments are visible to me as a speaker, but you can change your settings so that the comments are also visible to the other participants. There's also a function called the Q&A where you can submit questions that you want answered, and you may choose freely which of these channels that you use for your questions. So proceeding then to the contents of this presentation. This slide shows in summary that what I will be talking about today. And first, I will say a few words about the SCC as an arbitral institution. I will then proceed to give you some statistics from last year, talk about the organization of the SCC, and talk about who does what at the SCC, and then proceed to kind of the core subject of this session, namely the arbitral process under the SCC arbitration rules. And during this presentation, I will be talking about the arbitral process under the SCC arbitration rules, and then make some remarks regarding the differences in the procedure under the SCC expedited rules at the end of the presentation. So proceeding to describe the SCC as an arbitration institute just briefly. The Arbitration Institute of the Stockholm Chamber of Commerce is, as its name implies, an independent part of the Stockholm Chamber of Commerce and is one of the oldest arbitral institutions worldwide. The SCC was established in 1917, meaning that we actually celebrated our 100th anniversary in 2017. The SCC was established as a service of the Stockholm Chamber of Commerce, and in the beginning this service was primarily aimed at companies in the Stockholm region, but as many as you know, today this has changed and the SCC is today a truly internationally recognized institution. So how did the SCC reach its current position? Well, one contributing reason was actually thanks to Sweden's political position as a neutral country. Because of this, the SCC became a venue of choice for the resolution of East-West disputes during the 1970s and 80s, when the Soviet Union and later also China began to expand their economic relations with the West. The SCC's role as the venue for resolution of East-West disputes was formalized in two agreements set out here on the slide, that is an agreement of 1977 and 1984 respectively. So today then the SCC handles about 150 to 200 cases per year, and in average the SCC has handled about 190 cases per year during the last 10 years. The caseload here is very diverse and interesting, with about half of the cases being international cases, meaning cases where none of the parties are Swedish. And in fact, most of the international cases doesn't really have a connection to Sweden at all, except for perhaps the seat of the arbitration being in Sweden and the agreed application of the SCC rules. As you can see from this slide, the SCC is also known for its caseload having a relation to East-West disputes, to energy-related disputes, which could be both commercial or investment disputes, and also that the SCC is currently one of the world's biggest arbitration institutions for investment arbitration. And as far as we know at this point, the SCC is appointed, or the appointed forum for resolution of investor-state disputes in about 120 bilateral investment treaties, as well as in the Energy Charter Treaty. So, looking a bit closer on the nationality of the parties in the cases administered by the SCC, we have here a slide showing the nationalities of parties in SCC arbitration during 2019. So this is the statistics for last year, but the statistics tend to be quite similar from year to year, where we can see that the most common nationality of the parties are Swedish, followed by Russia, and then also followed by some other CIS countries. And here we have another slide with statistics, and this one tends to be quite interesting for practitioners and parties alike because it shows how long it takes for an award to be rendered in SCC arbitrations. And once again, this is statistics from the year 2019. And as we can see from the first two columns in this slide, about 77% of the cases during 2019 were terminated within 12 months from the request for arbitration. And then we have only a small minority of cases where the arbitral proceedings took longer than 12 months. And this minority of cases is represented by larger and more complex cases, be it commercial cases or investment cases. And regarding investment cases, the length of these cases tend to be between 3 to 5 years. So that explains why there are longer arbitral proceedings in such cases. So proceeding then to the organization of SCC, and I thought that this was a relevant slide to include because different arbitral institutions do have different organizational structures, which governs how cases are administrated and how decisions are made in those cases. I will therefore say a few words regarding the SCC and the different actors that sort of play a part within the SCC organization. And at the SCC, we do have a secretariat where I myself work, and the secretariat consists of 3 divisions on which the caseload is divided evenly. Each division consists of 1 legal counsel and 1 case administrator. The legal counsels and the case administrators administers the cases on their division and also acts as the primary point of contact for parties and arbitrators in pending arbitrations. So this includes answering procedural and practical questions from the tribunal and parties alike. In addition to the case divisions of the Secretariat also consists of a Secretary General, a Deputy Secretary General, and staff working with business development. And although some decision-making in the individual cases is delegated by the SCC board to the Secretariat, most decisions in cases administered under the SCC rules are in fact made by the SCC board. And the board consists of 15 members, of which 5 are Swedish and 10 are international. These board members are not employed by the SCC, but they are experts in arbitration with very diverse backgrounds in arbitration. So the Secretariat convenes with the board once a month, and during these meetings, which are nowadays, of course, held by video instead of in person, individual cases administered by the SCC are discussed and decisions are made in those cases by the board. Decisions to be made by the board under the SCC rules are quite diverse, but some examples include decisions on prima facie jurisdiction, decisions on, for example, consolidation of arbitrations, decision on challenges to arbitrators, and perhaps most important, the appointment of arbitrators. I could also add that the board members of the SCC are appointed by the board of the Stockholm Chamber of Commerce. Then we have a last group of people on this slide, and that is the arbitrators. And arbitrators are external specialists in arbitration, which are, of course, not employed by the SCC. Usually, the arbitrators appointed by the SCC will be attorneys or judges, university professors, or other sorts of experts, all depending on the dispute at hand. The arbitrators are appointed by the SCC board and are appointed in each specific case. One special feature of the SCC is that we do not have a list or roster of arbitrators from which arbitrators are appointed. This means that the parties can freely choose their arbitrator and that the SCC is free to find the most suited arbitrator for a particular case. So proceeding a bit on this track, I'll provide some more detail. I have covered some of these points on the last slide, but I would like to look a bit closer here on who does what at the SCC. And to start with the Secretariat once again, the Secretariat works with case administration and takes certain decisions which are delegated to the Secretariat by the board. And such delegated decisions include, for example, deciding on the costs of the arbitration or deciding on deadlines for party submissions, at least the initial stage of the proceedings and also the deadlines for the arbitral award. In connection to the meetings with the board, the Secretariat proposes actually various proposals for decisions to be made in individual cases and presents these to the boards as well. Besides the sort of day-to-day administration of the arbitral cases, the Secretariat is also very much involved with participating within the field of arbitration. This includes organizing and participating in conferences and panels and contributing to various books and articles on quite a wide range of topics within international arbitration. We also write a lot of articles which are published on our own website, but also in external channels as well. One example that is worth highlighting in this regard is that we regularly publish practice notes on, for example, the SCC board's decisions on challenge to arbitrators. And these practice notes give an insight into SCC practice on a variety of subjects. Looking then at the board and the arbitrators, I have already explained what their function are. The board makes decision in individual cases in accordance with the mandate given to the board under the SCC rules. And the foremost task of the arbitrators is, of course, to manage the arbitral proceedings and render decisions and awards. So, leaving then the organization of the SCC and looking instead to the SCC rules. You can see from this slide that the SCC has a number of different sets of rules. The most used ones are the standard arbitration rules. And actually, these are utilized in the majority of arbitration cases administered by us. However, we also have the expedited rules, and these are also quite frequently applied by the parties. And whether the normal rules or the expedited rules will apply in a certain case depends on the parties' agreement in the arbitration agreement. Besides the arbitration agreement, the parties may, however, also agree in front of the SCC in the initial stages of the proceeding to apply another set of rules than stated in the arbitration clause. As I said before, this presentation is focused on the SCC arbitration rules, but I will be mentioning some difference between the arbitration rules and the expedited rules at the end of the presentation. And as you can also see from the slide, both the arbitration rules and the expedited rules were both revised in 2017. Something to be mentioned here as well is that both the standard rules and the expedited rules contain a number of appendices. And both set of rules include actually an appendix with rules concerning emergency arbitral proceedings. This appendix contains rules for the appointment of an emergency arbitrator to decide upon a request for interim relief before the case has been referred to an arbitral tribunal. This means that an application for emergency arbitrator can either be filed before a normal request for arbitration, at the same time as a normal request for arbitration, or actually after the request for arbitration has been filed, but before the case has been referred to the arbitral tribunal. The provisions on emergency arbitrators were included in the SCC rules in 2010, and at that point the SCC was one of the first arbitral institutes to incorporate such provisions in the rules. Besides this, the SCC also provides certain ad hoc services, and these include being the appointing authority, which means that the SCC appoints an arbitrator in ad hoc proceedings, that is, proceedings that are not administered by an arbitral institution. It also covers deciding on challenges to arbitrators and certain other ad hoc services, such as record keeping or fund holding. Further, the SCC also maintains certain procedures to be used as tools in arbitrations covered under the unscriptural rules. And finally, the SCC also has and maintains rules for mediation. Let me just proceed to the next slide here. Yes, there we are. So on this slide, now we're kind of past the initial presentation of the organization, SCC, and our rules. So I would like to proceed to the core subject of this presentation. And on this slide, we do have an overview of the standard steps of an arbitral procedure under the SCC rules. And this chart shows the different steps of an arbitration from beginning to end. And as you can see, there's a dotted line in the middle of this chart. And this divides the arbitral proceeding into a first stage and a second stage of arbitration. So looking at the first stage, this is the initial stage where the case is handled by the SCC and where the arbitral tribunal that will in the end adjudicate the dispute has not yet been appointed. So the purpose of this initial stage is to establish the procedural framework of the arbitration, to appoint the arbitral tribunal, to decide the preliminary costs of the arbitration, and to decide certain procedural issues, which falls within the mandate of the SCC. This includes issues such as prima facie jurisdiction, for example. And this first preliminary stage will usually last for between 3 to 4 weeks, as you can see on the side of this chart. So looking a bit more closely at the initial stage of the arbitration, we can see that the arbitration starts with the claimant submitting a request for arbitration, which is then reviewed by the SCC. After reviewing the request for arbitration, the SCC will serve the respondent the request and may also ask the claimant to submit more information if this is needed under the SCC rules. The respondent then submits its answer, which is also reviewed by the SCC, and the claimant will usually get an opportunity to comment on the respondent's answer. This is the usual case, and especially the case if the parties disagree on any procedural matter. Following these initial submissions by the parties, the SCC will decide on the procedural issues that are contentious in the case, if any. The SCC will also decide on the advance on costs to be paid by the parties. And the advance of costs is an administrative matter, but really a very substantially important matter as well in the dispute, as the advances are an amount paid by the parties that are meant to cover the fees of the arbitral tribunal, the administrative of the fee of the SCC, and also expenses of the tribunal and of the SCC. And the main principle is that the preliminary advance of cost shall actually cover all costs in the arbitration. However, in some cases, the disputed amount will increase in the dispute, or the complexity of the case will be higher than anticipated. And in those cases, the arbitral tribunal may request from the SCC that additional advances of cost shall be collected by the parties. Upon such request, the SCC will review the request and decide whether additional advances shall be paid or not. I will be talking a bit more about the advances on cost and the cost of the arbitration later in the presentation. So this is just meant to be an overview of the steps. So once the advances has been paid, the SCC appoints an arbitrator, or arbitrators as the case may be. But the parties may also agree to themselves appoint a sole arbitrator if it is an arbitration under the expedited rules, or a chair of the tribunal if it is an arbitration administered by the arbitration rules, and the dispute shall be adjudicated by 3 arbitrators. So when the arbitrator is appointed, the arbitrator must submit a confirmation of acceptance, confirming that the arbitrator is impartial and independent, and also disclose any circumstances which may affect the arbitrator's impartiality and independence. And the appointment process is also something that I will be talking a bit more about shortly. So once the advance of costs have been paid, the arbitrators have been appointed, and all procedural issues have been decided. The first stage of the arbitration is over, and the case will be referred to the arbitral tribunal or the sole arbitrator if the expedited rules apply. From the day of the referral, the tribunal has 6 months to render an award under the normal arbitration rules and 3 months under the expedited rules. And as you saw from the statistics initially, this time may be extended by the SCC upon a recent request from the tribunal. This is quite common and is often the result of the tribunal and the parties having agreed on a timetable that exceeds the time limit set out in the SCC rules. So once the case has been referred, the tribunal shall hold a case management conference with the parties, and during this case management conference, decisions are made regarding the arbitral procedure and the timetable of the arbitration. The case management conference is usually held via phone or video and shall be held promptly after referral according to the rules. Following the case management conference, the proceedings before the tribunal will basically proceed in accordance with the agreements made during the case management conference. And this may include, for example, a jurisdictional phase if the jurisdiction of the tribunal is disputed, document production, written submissions, one or more hearings on the merits, also post-hearing briefs and cost statements and so forth. It all depends on the form of the arbitral procedure. So the also one quite common feature is for the tribunal to actually declare the proceedings closed following post-hearings briefs after the hearing in the case. And after all of this is finished, the tribunal will issue or render an arbitral award. But prior to rendering the arbitral award, the SCC will, upon the tribunal's request, determine the cost for the arbitration. And the costs for the arbitration include the same post as the advance on costs, that is the fees and expenses of the tribunal, the administrative fee of the SCC, and any expenses of the tribunal or the SCC. The cost of the arbitration and the liability of the costs as between the parties will then be incorporated into the final award. And once the final award has been rendered, the Secretariat will issue a settlement of accounts where the final costs of the arbitration as determined by the SCC is settled against the advance on costs already paid by the parties. And a quite common situation is that there is in fact a surplus on the case account after the costs of the arbitration, the actual costs, have been settled against the advances paid by the parties. And this may, for example, be the case if the tribunal has not had any expenses, then the costs may be lower than the advances. And if there is a surplus on the case account, the surplus will be repaid to the parties, and the surplus will be repaid in the same proportion as the advances were paid. So for example, if the claimant paid 50% of the advances and the respondent the other 50%, which is the standard case, the surplus will be paid out with a 50-50 proportion there as well. So as you can see on this chart, the whole proceedings from request for arbitration to the final award being rendered will usually take between 6 to 12 months. And after this, the award is circulated by the tribunal to the parties and also to the SCC. So before proceeding here with the next slide, I think I'm going to check if there are any questions so far. Can't see any questions.
We do have one question. I will answer it in the chat though, because I think it's better there. So, but you're most welcome, everyone, if you want to ask any questions on what we have covered already, or if there's anything outside of that you want us to cover. So please use the chat or the Q&A function for that.
Thank you very much. This was Lisa Alm, our business developer at the SCC speaking.
Yeah, sorry, I keep forgetting you can't see me. So, but yes, hi.
So proceeding then with the presentation, as Lisa said, just ask any questions that you might have, and I will try to answer them at an appropriate point in the presentation. So on these next few slides, I would like to examine some of the steps of the arbitration a bit closer. And it is, of course, logical then to start with the first step in the first stage of the arbitral proceedings, which is the request for arbitration. And the rules actually list what the request for an arbitration must include. These requirements are found in Article 6 of the rules. And I will not mention all of the requirements in this presentation, but I will mention some of them that I deem to be of particular importance. So in short, the request shall include a preliminary request for the relief sought and a monetary estimation of the claim. It should also include the grounds for the request and a description or a copy of the arbitration agreement. Normally, this means that the parties' commercial agreement with the arbitration clause will be included in the request for arbitration, and this is often beneficial as well, because at some point in the arbitration, the commercial contract will usually have to be provided anyways. And the monetary estimation of the claims is of particular importance because this is needed to determine the advance of cost, because the advance of costs are determined in accordance with a table of costs attached to the SCC rules. And in the table of costs, the advances from costs are based on the disputed amount in the case. So this is why it's important to include a monetary estimation. So this is sometimes called an ad valorem value, where the advance of cost, ad valorem model, where the advance of costs are determined by the disputed amount in the arbitration. Yes, and as I mentioned before, the Secretariat will examine the request for arbitration in accordance with Article 6 and see that it contains all the information required, and may also request further details from the claimant pursuant to Article 10 in the rules. Looking then a bit closer to the respondent's answer to the request of arbitration. It is also set out in the rules what the answer shall include. This is set out in Article 9, and like the request for arbitration, I will not mention all of these criteria, but instead just dwell on some of these. First, the answer shall include any objections to the arbitration agreement. This could be regarding the validity or application of the agreement, but it is also important to note that a failure to present objections at this initial stage does not preclude the respondent from doing so at a later stage. Naturally, the answer also has to include an admission or denial of the relief sought by the claimant and a preliminary statement of set-offs and counterclaims and a monetary estimation thereof. And the monetary estimation is important here for the same reasons as the monetary estimations in the request for arbitration. One important point that is quite important to mention is that a request for joinder, that is a request from any of the parties really, for a third party to be joined to the arbitration, must be submitted as early as possible and no later than in the answer to the request for arbitration. Usually all of this provision does apply to both the claimant and the respondent. A request for joinder is usually put forth by the respondent and not the claimant. So the consequence of not presenting a request for joinder at the latest, together with the answer to the request for arbitrations, is that the request will be precluded unless the board decides otherwise. So proceeding to the next step of the initial stage of the arbitral proceedings, which is the formation of the arbitral tribunal. The first relevant question to ask, I think, is who may be appointed as an arbitrator. And as I mentioned, or perhaps I didn't mention that, but anyways, the SCC does not maintain a list of arbitrators and doesn't have a roster of arbitrators. But there are still a few requirements that the arbitrators must fulfill. And according to the Swedish Arbitration Act, an arbitrator must have full legal capacity and be over 18 years old, or have full legal capacity, which means that the arbitrator has to be over 18 years of age and not be subject to bankruptcy proceedings and so forth. This is perhaps quite unsurprising. More importantly, however, the SCC rules and the Swedish Arbitration Act requires arbitrators to be impartial and independent in the dispute at hand. Of course, this is quite similar to most rules regarding arbitral proceedings. Looking at the constitution of the arbitral tribunal, something to be remembered is that the SCC arbitration rules does not establish any default rules on how many arbitrators shall be included in the arbitral tribunal. This is different from the expedited arbitration rules, which are always adjudicated, according to which disputes are always adjudicated by a sole arbitrator. In the majority of cases, the parties have agreed on the number of arbitrators in the arbitration clause or in the initial stages of the proceedings. However, if the parties cannot reach such an agreement, the number of arbitrators will be decided by the SCC. There is one example to this general rule, and that is set out in an appendix to the SCC rules, according to which the number of arbitrators shall always be 3 in investment cases. This is due to those cases usually being quite complicated and comprehensive. A final note is that the Swedish Arbitration Act does not contain any provisions of limitation of liability for arbitrators, but this is in fact included in the SCC rules, in Article 52, so the last article in the rules.
Christoffer,
Yep.
before you move on, we have a question.
Sure.
So I'm going to read it aloud, and it is, in order for an arbitration to take place with the SCC, should the SCC be mentioned in the arbitration agreement, or can parties agree on it once the dispute has arisen?
Yes, thank you very much. That is a very good question. And actually, both options would be viable. I mean, the normal thing is that, of course, the SCC is mentioned in the arbitration clause, and we do have model clauses on our website where you can see how the SCC should be mentioned in order to there not to be any doubts as to that the arbitration shall be administered by the SCC. There is an option for the parties to agree in front of the SCC that the dispute shall be administered by the SCC as well. But the safest option is obviously to already have this agreed in the arbitration clause.
There's a little bit of a tendency that when they are already in dispute, they can't agree on the color of the sky sometimes. So having a pre-agreed might be a good idea.
Thank you. Do we have any more questions? Or was that?
Not right now.
Great. Okay, I will proceed then, looking a bit closer on the formation of the arbitral tribunal under the SCC rules. And the next logical question, of course, when we have established who may be an arbitrator, is how arbitrators are appointed. And as in arbitration in general, the principle of party autonomy is, of course, central in the appointment process, and the appointment process will thus follow the arbitration clause in the parties' agreement. However, there is a default procedure set out in the SCC rules and also in the SCC model clause, and this is also the most common procedure chosen by the parties. According to the SCC rules, in cases where the arbitral tribunal shall consist of 3 arbitrators, the parties each appoint 1 co-arbitrator, and the SCC board appoints the chair of the tribunal, and this is unless the parties agree otherwise. Under the expedited rules, the dispute shall be adjudicated by a sole arbitrator, and the parties are given a period to jointly appoint the sole arbitrator, and if no arbitrator is appointed by the parties in that period, the arbitrator will be appointed by the SCC. So as I mentioned before, the SCC does not have a roster of arbitrators or a list of arbitrators, and the parties are free to select any person of any nationality. But when the SCC chooses an arbitrator under the SCC rules, there is actually one additional requirement, and that is that the chair of the tribunal should have a neutral nationality, meaning not the same nationality as any of the parties. And when the SCC appoints arbitrators, we look at a number of different factors, such as the complexity of the dispute, the amount in dispute, the nationality of the parties, the language of the proceedings, the applicable law to the dispute, and of course the expertise of the candidates in light of the merits and subject matter of the dispute at hand. So that's something about appointment of arbitrators. So as I mentioned initially, yes?
We do have a question as well on the appointment of arbitrators.
Of course.
And I might be, so the question goes like this: what if the parties agree on, and they each choose 1 arbitrator, and then the arbitrators wishes to choose SCC as the head of the tribunal? So I'm not, yes, I'll leave that one with you.
I'm not entirely sure how to understand that question. It is the part about the SCC as the head of the tribunal that confuses me, I think.
Exactly. It might be a confusion with, so the SCC never sit themselves as arbitrator, we just appoint it, but the SCC obviously can appoint the chair of the tribunal, which I think is what Christoffer has just gone through. So maybe that's the confusion, but the yes, I think
yes. One procedure that we do see is that the parties have agreed that the co-arbitrator should appoint the chair of the tribunal. So that is another option that occurs. It's not that common, but it occurs. It might be, maybe that was the question.
Yes. So if you are welcome to elaborate on that question, unless we have managed to answer it in my somewhat confused rambling there.
Thank you. So we'll see if we get a clarification on that. In the meantime, I will continue with challenges to arbitrators, because as I mentioned initially, there is a requirement for arbitrators to be impartial and independent. So a relevant question to ask is then, how is this principle safeguarded under the SCC rules? And according to the SCC rules and also the Swedish Arbitration Act, a party can challenge an arbitrator at any time during the proceedings leading up to the award. After the award has been rendered in the case, the impartiality and independence of arbitrators cannot be challenged, but the award in itself can of course be challenged in accordance to the provisions in the Swedish Arbitration Act. So looking first to the Swedish Arbitration Act, we can see in section 8 that an arbitrator shall be discharged if there exist any circumstances which may diminish confidence in the arbitrator's impartiality. A challenge must be made within 15 days from when the party became aware of the circumstances giving rise to the doubts. And similarly, according to the SCC rules, a party may challenge an arbitrator if circumstances exist that give rise to justifiable doubts as to the arbitrator's impartiality or independence. And also under the SCC rules, the challenge has to be made within 15 days from the date that the circumstances giving rise to the challenge became known to the party. So what follows then is that the relevant question for the board when determining challenges under the SCC rules are whether justifiable doubts exist or not. And actually the SCC rules does not define justifiable doubts, but in its determination of challenges, the SCC has quite a strong practice of employing an objective perspective, meaning that doubts are seen as justifiable if a reasonable third person would conclude that the arbitrator may be influenced by factors other than the merits of the case when deciding in the case. This objective standard is also set out in the International Bar Association's guidelines on conflict of interest in international arbitrations, and these are called the IBA guidelines usually. And the IBA guidelines also contain various standards, which are examples of situations where justifiable doubts may be at hand. And the SCC board, in its determination in challenges, often considers the IBA guidelines when assessing challenges. But of course, the board may choose to deviate from these standards when making its decision.
I have a couple more questions for you.
Yeah, perfect.
If this is a good break for them.
I think it is.
Perfect. So one question is, if one part, what if you have, if one part have double nationality, which one is used or which one is referred to? I imagine this is party, but I could see that that the question could apply also to the arbitrator.
Yes. So the question then becomes, let's start with the party situation. So if a party has a double nationality, I haven't actually experienced that myself. Usually when companies are parties, of course, they will be seated in one country. But I guess that the principle will be to try and appoint a completely neutral arbitrator in that case as well. So not of any of the nationalities of the parties.
And when it comes to the arbitrator?
Well, this is basically the same thing. So if the arbitrator has dual nationalities, these will be seen as if any of these are the same as the nationalities of parties, that arbitrator probably wouldn't be appointed.
And then I have one more question. Does the SCC accept to apply non-state law in international contract disputes, such as religious rules? Is there a sample of decisions regarding this?
Well, this is actually not a matter for the SCC. This is a matter for the arbitral tribunal. So this will depend on well, the tribunal and the rules governing the conduct of the arbitral tribunal, because choice of law is something that is decided by the tribunal and not by the SCC. So the typical lawyer answer becomes, it depends. There is no set rules in the SCC rules.
Perfect, thank you. And one more question. With regards to the arbitrator, what is the difference between impartiality and independence? Well,
that's a good question. Almost a semantical or philosophical question, I guess. Well, they usually do blend together quite some, but both relate to the relation between the arbitrators and the parties and the counsel. So there is a difference, but they are usually treated as one.
Okay. Hope that you're happy with the answers, and otherwise follow up in the Q&A. But that was the questions we had for now.
Perfect. Thank you very much. Very good questions. So I will then continue with looking at the further steps that were outlined previously in sort of the overview of the procedure. And now we have reached a stage where the case is referred to the arbitral tribunal from the SCC. And according to Article 23 of the arbitration rules, the tribunal is obligated to handle the arbitration in an impartial, efficient, and expeditious manner. And these are, of course, cornerstone principles in international arbitration generally. And as you probably understand, this general provision gives arbitrators quite the broad mandate to conduct the proceedings in the way that they deem to be most appropriate in the particular case. Usually the first step after the referral of the case to the tribunal is, as I kind of mentioned before, to hold a case management conference, which shall be held promptly after referral according to the rules. At the case management conference, the tribunal will organize, schedule, and also establish procedures for the conduct of the arbitration. And during or immediately after the case management conference, the tribunal will establish a timetable for the arbitration, including the date for rendering the award. And for the purpose of efficiency and expeditiousness, the SCC Secretariat monitors the arbitral proceedings. And at the end of the proceedings, the tribunal is required to submit a report of the work performed by the tribunal, as well as a summary of the proceedings, which the Secretariat then considers when determining the final costs of the arbitration. And the cost is something that I will be talking a bit more about shortly. Yes, I think that's it for this slide. So before proceeding further down the ladder, I think that I would like to mention one special procedural tool set out in the rules, which is summary procedure. And this mechanism allows for the parties to request a decision of the tribunal to decide issues of fact or law without undertaking every procedural step of the arbitration. This is basically a tool which allows for further efficiency and expeditiousness of the proceedings by deciding an issue that is important to the dispute, but without taking all of the procedural steps that are normally taken, such as party submissions. In Article 39 of the rules, there is an enumeration of examples of issues that can be subject to summary procedure, but the list is not exhaustive. Something to be noted is that there is no deadline for the request for summary proceedings or summary procedure, or for the decisions in summary procedures to be made under the rules. So this is entirely for the arbitral tribunal to decide. So, and I would also like to talk briefly about a couple of new provisions introduced in the 2017 version of the SCC rules, which is the latest version of the rules. First, we have the provision regarding administrative secretaries, and these are set out in Article 24 of the arbitration rules. And even before this change, there was actually an established practice of administrative secretaries in arbitrations, but this was a way of codifying those principles. And something to be kept in mind here is that the tribunal may at any point of the arbitration submit a proposal to the SCC for the appointment of a specific candidate as an administrative secretary, and the parties have to approve of that specific candidate. And the candidate must also submit a CV and a declaration of impartiality and independence, just as the arbitrators. The tasks of administrative secretaries are not explicitly set out in the rules, but these tasks include like administrative and clerical tasks and may not include decision making. There is also a procedure for the removal of administrative secretaries, and this is the same proceedings as for arbitrators. Another interesting addition to the 2017 SCC rules is that parties may now ask for security for costs. And this option also existed before in practice, but it was included as a codification in the SCC rules. And these provisions are found in Article 38. Finally, a small gap in the rules was filled by including provisions that allows for emergency arbitrators to make cost decisions in the emergency decisions.
I have a question for you, if this is a good time. It is.
Yeah, I think it is.
Okay. It is concerning the Achmea decision of 2018.
Yeah.
And its impact. What is the impact of the Achmea decision of 2018 to the SCC rules? And I'm guessing maybe not all of our listeners are fully on top of the Achmea verdict or decision, so it might be, maybe I should say a sentence or two on what the implications of that was. Or if...
Sure. Exactly. So,
do you want?
Yeah, you could jump in. I think we're a bit short on time here. I'm just looking on my slides and see what I have to.
What you have to cut?
What I have to cut.
Okay,
let's do. The Achmea decision is kind of a separate decision.
Let's return back to that question at the end of the hour, if we have time for it.
I think perhaps that would be a good idea because I'm looking a bit short on time. So let me go through the procedure first. Perfect. Because the Achmea decision, I believe, is quite, like I said, a separate discussion from the arbitral proceedings.
Yep.
So proceeding then to the costs of the arbitration. I mean, this is a very important topic to discuss when discussing any form of dispute resolution. And I will first be saying something about the costs incurred by the parties in the arbitration. And according to Article 50 in the rules, the tribunal may order one party to pay any reasonable cost incurred by the other parties, such as fee for legal representation. And the tribunal may do so considering the outcome of the dispute and also to which extent the party have contributed to the efficiency and expediousness of the arbitration. Something to be noted here is such costs must actually be requested by the parties. Looking then to the costs of the arbitrations, which I have been mentioning before, these consist of the fees of the tribunal, the administrative fee of the SCC, and any expenses of the tribunal and the SCC. And according to Article 49 in the rules, the tribunal shall request that the SCC determines the cost of the arbitration before making the final award. The cost shall be included in the final award and must also be specified in the dispositive or operative part of the award. So it's not enough for the cost to be stated in the reasons of the award. Also, the cost should be specified individually, so there shouldn't be just a specification of the aggregate costs of the arbitration. And as I mentioned before, the tribunal's fees and the SCC administrative fee is determined based on the disputed amount in the case in accordance with the ad valorem model set out in the appendices to the SCC rules. However, in cases where the disputed amount exceeds 100 million euros, the determination is made by the board on a case-by-case basis. The administrative fee of the SCC is also capped at 70,000 euros. As for the expedite rules, the costs will be determined by the board if the disputed amount exceeds 5 million euros, and the SCC administrative fee is capped at 35,000 euros. So this kind of shows that the expedited rules are meant to apply to smaller cases. A special feature of the Swedish Arbitration Act is also set out in section 41 of the Act, and that is that the arbitrator's fees may be challenged in the Swedish courts, and the party that wishes to file a challenge must do so within 2 months from the final award. And if the party does not do so within 2 months, the right to challenge the fees of the arbitrations or the fees of arbitrators are lost. And I would say that it is quite rare for us to see such challenges, and the court practice in this regard is quite scarce. So I think I will go through this last slide of the presentation, and then we can have a discussion on the further questions. Because as I promised in the beginning, I wanted to talk a bit about the SCC expedited rules as well, as most of the presentation so far has been focused on the SCC arbitration rules. So the expedited rules were first drafted and enacted in 1998, and at that time the expedited rules were actually somewhat unusual. Today, however, the expedited rule has gained quite a strong foothold, and in 2019, about 30% of the cases administered by the SCC were registered under the expedited rules. The whole idea of the expedited rules is to sort of allow for an arbitral procedure aimed at smaller cases, which is an arbitral procedure that is quicker than arbitration under the normal rules. So the expedited rules provide for front loading of the case, meaning that the request for arbitration also serves as a statement of claim, and that the answer to the request also serves as a statement of defense. This means that once the case has been referred to the arbitrator, the parties have already really submitted their main submissions on the merits of the case, and in theory, there might not be need for additional rounds of submissions in front of the arbitrator. In practice, however, we do see that the arbitrator decides upon request often from the parties that additional rounds of submissions shall be submitted. And to reflect the principle that the merits of the case shall be more or less established when the case is referred to the arbitrator, the respondent is given a bit longer to reply to the request for arbitration under the expedited rules than under the ordinary rules. In some situations also, this is something that I also wanted to note, is this is somewhat of a common practical situation, and that is that the parties have agreed that the expedited rules shall apply to an arbitration, even if the dispute is at hand is actually too big or too complex for the expedited rules. And this may be the case in cases where the disputed amount is particularly high, or where the dispute involves complicated procedural or issues or complicated merits. In such cases, the SCC may, in accordance with Article 11 of the expedited rules, invite the parties to agree on a rule swap, meaning an agreement between the parties that the arbitration rules are applied to the proceedings instead of the expedited rules. It is important to note, however, that the SSC does not have the power to take this decision unilaterally, so it has to be an agreement between the parties to switch to the arbitration rules. However, this is usually in the best interest of the parties to actually get a form of arbitral proceeding that is better fitted to the dispute. Something about hearings under the expedited rules. The standard for the arbitrator deciding that a hearing shall be held in an expedited case is actually higher than under the arbitration rules. And usually a hearing will only be held at the request of a party, and if the arbitrator finds that the reasons for holding a hearing is compelling. With that being said, we can see that in many expedited cases, hearings are actually held in order to sort of collect oral evidence brought by the parties. And also, a final note here is that the costs, as I mentioned before, of expedited proceedings are usually on the lower end as compared to arbitrations under the arbitration rules. So that was the presentation, and I see that we do have about 4 minutes left on this session. So I think this might be a good point to perhaps answer some questions.
I have two questions for you. One is the Achmea one, but I also have another question that is it possible to start the emergency procedure for an interim relief, even if there is an escalation clause, i.e. a negotiation or mediation precondition for the SCC arbitration?
Okay, so there is an escalation clause in the contract, and the question is whether it would be possible to initiate emergency proceedings. That is a very good question, and a question that I actually haven't encountered in practice. I think this would have to be a point to be made. Sorry, a determination to be made by the board in the particular case and looking at the particular clause. But generally speaking, I do think that it would be possible, since the point of the emergency proceedings is to kind of allow for interim decisions before the normal arbitral procedure.
And my understanding as well is that this may differ a little bit between jurisdictions, but under Swedish law, an escalation clause is not a hindrance to go into a proceeding, if I'm not mistaken. And here you are the better expert than I am, but has been my understanding.
Yes.
And then, if we don't have any other questions when it comes to the proceedings, which I don't have in my list here right now, I don't know if you feel 2 minutes is enough to say something about Achmea. I agree with you; it's slightly different to the proceedings.
It is, and I'm actually not quite sure if this has affected the SCC rules. Maybe you know that, Lisa.
It hasn't really. So, I mean, the Achmea decision is a decision saying that, and this is gonna, I'm on slightly thin ice to sum this up from the top of my head, but it essentially says that you cannot use bilateral investment treaty dispute so many words dispute resolution within the EU, then you have the EU rules will surpass, which means that if you have a case which it has an investment treaty protection and which concerns an investment treaty protection, that's one of the cases that we are very big with at the SCC, then it cannot be if it's challenged and it goes to a national court, it may be thrown out. So that was some of the concerns that the Achmea court arisen, but it hasn't really affected SCC as such. It may affect the inclination of using using European seats for these type of cases going forward, but it hasn't affected SCC.
Yes, I think that's a good summary, and especially given the shortage of time here. And I guess the only practical consequence that could be seen is that, like you said, Lisa, that we will get fewer investment cases, intra-EU investment cases, but I'm not sure to which extent we have seen that at this point.
Exactly. And I mean, there will be a lag in those situations as well. So whether or not we're going to see that in 2 to 3 years or so from now, that we can see, but there hasn't been an immediate effect on the number of investment disputes that we have at the SCC.
Yeah. Perfect. So do we have any additional questions, or was that it at this point?
I think we are at the end of the line here.
And that, I'm looking at the clock, and it seems like this would be quite a good time to finish as well. So what I would like to say then is just thank you all very much for tuning in to this webinar. On the last section of the slide, which I think you can see now, my email address should be written, and otherwise it's on the SCC website as well. And you're of course welcome to use that should you have any questions. So thank you very much. And I hope to see you all in persons at sometime in the future.